Well, good afternoon, ladies and gentlemen, and welcome to Australian Business Lawyers and Advisors' first webcast. And today, myself and my fellow director, Lewis Izzo, are going to be talking about preparing for the silly season, your risks and responsibilities. So the objectives of today are that we are going to talk to you about how you can prepare your organisation for the party season, steps to take to minimise or prevent incidents occurring in your workplace, and what to do when things go wrong. Lewis, you might take us through the agenda.
Certainly. In terms of the agenda, we're going to look at probably three key categories. We're going to look at out-of-hours conduct, and by that we mean what the employer can and can't regulate and respond to about conduct or employee conduct that happens outside of the workplace. We're going to talk about tips specifically for managing workplace social events, parties, other type social events, and the types of things you can do to really get on top of that and ensure that you minimise your business's exposure to liability. And then we're going to talk about dismissing employees or disciplining them for misconduct that might happen at a work event. So they're the three kind of chunks that we're going to try and chew off over the course of the next 50 minutes or so. And hopefully by the end of it, we'll all be a bit more enlightened about the various principles in this area of the law.
Yeah, definitely. I think everyone's going to get probably a little bit more, take a bit more from the cases that we're going to talk about. We're going to talk about a very old case, which is really important and seminal, and then some of the more recent cases, which will try and explain the confusion created by those cases.
So in terms of out-of-hours conduct, the general starting position, which probably might not be uncontroversial or surprising to some, is that employers do not have the right to control or regulate what someone does outside of the workplace. So when you are not at work, when you are not during work hours, in those circumstances, an employee is in their own personal time, their own private time, and that is an area and a space that the employer doesn't usually have the right to enter into. And by that I mean you don't have the right to really be requiring people to tell you about what's happening during those times or disciplining an employee for what they do during those times. That's the starting position that any type of discussion in this area of the law commences from. And then we look at, well, what are the exceptions to that? But that is the general rule.
Well, of course, we get asked a lot about how to manage issues outside of that environment, and that's what today's all about.
Yes, and so, I mean, what are the business risks? When can you actually step in and look at disciplining or speaking to employees about what happens outside of the work? And the seminal case, as Joe mentioned, is Telstra and Rose. Now, in our office, Joe's usually the storyteller, if you ask any of our legal staff, but I'm going to try and steal that off him because I love this case, and it is quite a story. So I might kick off and then we'll probably cut across to Joe at some point as well. Telstra and Rose, it now dates back a while, it's 1998, and the decision maker in that case was then Vice President Ross of the Australian Industrial Relations Commission. Now, as it so happens, Vice President Ross is now the President of the Fair Work Commission, but back then he was a Vice President on the AIRC, as I said. And a case came up where Telstra dismissed Mr Rose and Mr Rose brought an unfair dismissal claim. And this was broadly the factual scenario. Mr Rose was travelling to a regional area out of Sydney for the purposes of doing some cabling work for Telstra. So he'd been asked by his employer to go to a regional area. It was a few hours, from memory it was southwest of Sydney, but it was a few hours out of Sydney. He gets to the location and he sees his supervisor. The supervisor says, "Oh, g'day, great to see you, Mr Rose. We've got this work that we need you to do." And he had a colleague there, and he said, "You can stay with the colleague. He's got a hotel room already. You can stay with the colleague. That'll be your accommodation for the next few days." Mr Rose says, "That's great." And off they go and they do their work. And for the first few days, there wasn't really any issue. At that point, we get to Friday, and what happens after Friday? Friday night. And Mr Rose and his colleague, they get on quite well. They end up going to the pub for a few drinks. And the case says that according to Mr Rose, he had 4 or 5 beers at the pub with his colleague, and then they proceeded to go to a nightclub after that. And Mr. Rose says at the nightclub that he had about 3 rum and cokes. Now, that's what the case says. Whether Mr. Rose's recollection is a conservative estimate or a generous estimate, we'll never know. But he'd obviously had a bit to drink. At the nightclub, there's 2 things that happen. At some point, a female becomes involved, and the evidence is a bit murky, but essentially they meet a girl. There's some argument between Mr. Rose and his colleague, and eventually Mr. Rose just has had enough, and he's like, you know what, I'm not going to put up with this anymore, and he kind of tells his colleague, if we put it politely, to just kind of get stuffed, and he storms off, and he goes back to the hotel room. So he storms back off to the hotel room, and if he'd just gone to bed there, then we wouldn't be talking about it now, we wouldn't have the case, he should have probably just gone to bed. That's not what he did. This is where it does get a bit interesting. He gets back to the hotel room and he rearranges the furniture of the hotel room into a boxing ring shape. So he's basically moved the lounges out, he's set the perimeter, and he waits for his colleague to come home. The colleague comes back, and mysteriously this girl has now appeared, and she's in the corridor of the hotel room with him, and he kind of wisely knows something's up because he tells the girl to step back a bit. He walks in, and Mr. Rose is there waiting for him. Mr. Rose basically says, you wanted your fight, you wanted your boxing match, here I am, and effectively propositions him for a fight. What happened next was, I think, takes everyone by surprise, and it does every time we kind of go through the story. The colleague walks straight past Mr. Rose, goes straight up to the window of the hotel room, punches his hand through the window, smashes the glass, grabs a shutter glass, and stabs Mr. Rose in the chest. And at that point, Mr. Rose is probably no longer trying to fight the colleague. He's actually got a gaping hole in his chest, and which requires an inordinate number of stitches. It's quite a serious incident, obviously. It may come as no surprise that Telstra dismissed the colleague and dismissed Mr. Rose. The colleague never brought an unfair dismissal claim. I don't know why, maybe because he ended up in prison, I think, for assault. But he had the good sense not to bring an unfair dismissal due to the nature of his conduct. But Mr. Rose did. Mr. Rose said, I was unfairly dismissed, and brought his case to the Fair Work Commission. And at that point, the Fair Work Commission had to determine, well, did this behaviour take place at work? Does the employer have an interest in what has gone on? And the Vice President set down 3 categories of conduct which the Vice President said that an employer can legitimately take an interest in and discipline someone about. And those principles are up on your slide. The first is that the conduct needs to be likely to cause serious damage to the relationship between employer and employee for an employer to be able to discipline because of it. It's got to be likely to cause damage to the employer's interests or be incompatible with the employee's ongoing duties as an employee. So the Vice President said ordinarily this should not have any relationship to Telstra. Telstra should have no interest in the event because it was outside of work. But does it tick off one of those 3 requirements or 3 boxes? Is there some reason that Telstra has a legitimate interest in disciplining Mr. Rose? And the Vice President said, well, it was outside of work. They weren't in Telstra uniforms. They weren't on call. Didn't really seem to have any ongoing impact in the workplace. I mean, the other colleague's gone. He wasn't back. He I think, did end up in prison. And so the question became, well, what was the connection that impacted upon Telstra? Telstra said, well, they ended up in the local court the next week and there was a bit of local publicity in the local paper and that was sufficient to make us concerned. But ultimately the Vice President said, no, you didn't actually establish that there was serious damage to the employer's relationship, there was no damage to the employer's interests, and that it was incompatible with the employer's duties. You didn't actually get over the hurdles you needed to. He found the dismissal was unfair and Mr. Rose won his case. And to me, I don't know, and I'm going to cut it back across to Joe now, to me this represents really the very thin grey line between what could be acceptable and what couldn't, in the sense that I think some people say, well, really, it seems pretty serious and it did happen between 2 employees. Probably Telstra should have been able to do something, but you also can kind of understand the Vice President's reasoning. So to me, it's kind of this case is the borderline. So it's both the seminal case, but I think if you went one step further, if there was one little bit more connector to the workplace, you'd probably think you'd end up with a decision the other way. So I see it as the middle ground.
Look, I think that's right, Lewis. I think that when you look at this case, it is that thin grey line, but when you do look at it and you pull the case apart and you pull apart the investigation conducted by the employer, you realise that there's probably more the employer could have done before they moved to dismiss the employees that may have bolstered their case around reputation and the impact on the organisation. I think one of the things you've got to be careful in these cases, and it's a lesson from Telstra and Rose, is don't become so focused on the societal repugnance or the seriousness of the conduct that the person engages in. So here they were very much focused on the fight, very much focused on their silly behaviour giving rise to the escalation to the fight. Then there was the stabbing by Mr Rose got stabbed by his colleague. I think ultimately the colleague, they were going to dismiss him, but he was allowed to resign. That was another mitigating factor as well. In the unfair dismissals, we know you've got to treat employees with parity and make sure they're treated equally, and this guy actually stabbed Mr Rose. Mr Rose was dismissed ultimately, and that created a difficulty for the employer in challenging this case as well. But it is that thin grey line, and some of the cases, in fact a lot of the cases you will find will then fall into that latter category where you can get one of these points of connection that the Vice President put out there, and I'll just repeat them very quickly because they're the three most important things. That the conduct is likely to cause serious damage to the relationship between the employer and the employee, or that the conduct is likely to cause damage to the employer's interests, or the conduct is incompatible with the employee's duties as an employee. That is repudiation of the employment contract. Those are really the 3 points, and whilst each of these cases turns on its own facts, it's important to understand what the lessons learned from each of these cases are.
So that's really the gold standard in terms of what the Commission looks at. If we now move to the topic of today's seminar, which is, well, what about work events? Is a work event in work time? Is it not? That's the kind of question that we need to often ask ourselves. If it is organised, promoted and funded by work, take a Christmas party, end of financial year party, it's going to likely be considered to be an extension of the workplace, particularly if it's during normal working hours, but even if it's not. I think if a business puts on a work event that they're clearly putting on for their staff, everyone's invited, I think that's when you're getting to a sufficient connection to work. If it's not organised officially by the employer, if it doesn't take place during working hours, if it's only organised by a few individuals within the employer, that's when you're likely to see the event itself perhaps be considered not to be an extension of the workplace.
You know, I think when we're looking at how you draw a line between a work-related event and a non-work-related event, we're not just talking about the importance from an unfair dismissal perspective or taking disciplinary action. We're talking about broader legal risk as well, because if it's in the workplace or it's a work-related event, you can have those flow-on effects from a workers' comp perspective. Now, of course, you know, there's a whole range of arguments available on the workers' compensation legislation as to why a matter should be arising out of or in the course of someone's employment and therefore attract compensation if there's an injury associated with it. We'll leave that conversation for another day. We're just going to talk about how you draw the lines and the issue of discipline for today. Yeah.
So that really leads us into the next case, which was decided about 2 years ago or so now, which is Keenan and Leighton Borrell-Amy. And I was wondering whether, I was going to ask you a question before we get into this, Joe, about, well, what happens if you kick on after a work event? And where does that leave us? Now, I don't know if that's a question better answered now or after we discuss this case, because this caused a lot of commentary at the time, because the conduct that we're about to talk about was quite reprehensible. But again, the Commission had a very clear focus about, well, is this part of the workplace or isn't it?
They did, and when we start to go through the facts of this particular case, you'll understand that the particular member that decided this decision, Vice President Hatcher, did take what we probably consider to be a slightly old-school view about drawing a line between what happens at work and after work. But it is helpful, and it's a good reminder for businesses that you do have to be careful around these particular points that arose in this case, but maybe you can talk us through the facts of the case.
So the case essentially involved an employee, Mr. Keenan, and his employer, which was a joint venture between Leighton and Borrell, and the business was known as Leighton Borrell Amy. The employee, it's a little bit like the Telstra Rose case in a sense. It always starts with a pre-drink. He actually had a beverage, I think it was a single beverage before coming to the party, but he then turns up to this event, and lo and behold, much to his delight and the delight of many people perhaps who are listening today, he discovers it's an open bar. And by that I mean it's all there for the taking, and there's no one even handing out the drinks. You just go in and serve yourself, and it appears that he very much did so. And so he had a few, he clearly became inebriated, and he did three things at the Christmas party that I think everyone accepts should not have been done. I think everyone accepts were misconduct, but I think there's a broad level of acceptance that they're not sackable offences either. He told a director of the Leighton Borrell Amy joint venture, he didn't know who he was, and he kind of said, "Who are you?" and eventually tells this director to F off. So that's his first item of misconduct. He then says to another employee, "What do you even do here? No, seriously, who the F are you? What do you even do here?" So quite aggressive, inappropriate behaviour, again warranting a discussion, a disciplinary process. And then finally, he had this very odd conversation with a female employee. The whole conversation, the judgment, it's a bit awkward the way it's recounted. He kind of talks a bit about her children, and then also talks about, "I want to ask for your number, but I didn't want to be rejected." And there's kind of, it's a little bit of an socially awkward discussion, but it involves a kind of advance of some description indirectly laid through there.
And I think he also, during that conversation, I think this is important as well when you're thinking about the action that was taken. In that conversation, he conducts a character assessment of her, of what he perceived her to be like, and then says, well, Ryan says that one of their other colleagues says, "You're okay, so you must be okay." But she's quite hurt by that and upset. And I think as a result of the investigation that was conducted, at the end of the day, it was determined that he had really impacted upon these individuals, that he had offended and sworn at and disparaged to their faces.
And so Vice President Hatcher, and I agree with this, found that these incidents warranted disciplinary action, but they didn't warrant dismissal. And I think we can live with that. I think those three incidents perhaps did warrant very serious response, but you can understand, you take into account length of service, other performance factors, maybe he's getting a final written warning. Where this gets really difficult is what happened afterwards. So the event, it concludes at 10 p.m. It's in a hotel type facility where they had the event in like a conference room or ballroom in the hotel. The event ends and everyone moves to what we'll call the public bar in the hotel, and this is where Mr. Keenan really kind of hits his I don't want to say finest moment, but he hits his most inappropriate. He does three further things. He says to one employee, "I used to think you were a stuck-up bitch, but Ryan says you're all right, and if you like you must be okay." So that's, again, I mean, perhaps not at the extreme end, but pretty inappropriate. He then proceeds to kiss another female employee on the lips without warning. He grabs her head with both of his hands, kisses her, says something. It was contested where he said it was your Christmas kiss or something like that, but clearly inappropriate. There was absolutely no warning. And then he told another female colleague it was his mission that night to find out what the colour of her underwear was. To which she responded something like, "They're white, and if you touch me, you're effing dead." And that was kind of that exchange. That was obviously the much more serious conduct. He was dismissed. In my view, there's no surprises there. And this is where the Vice President went into the whole discussion about, well, is it actually conduct in the workplace? And the Vice President said, well, it's not at work anymore. The Christmas party ended at 10 p.m. They're actually in the public bar now. And so he said, I'm not satisfied it's at work, so we need to go back to those three questions that Joe mentioned from the Vice President Ross case about, well, is there some incompatibility with the ongoing employment? Is there some serious damage to the employer? Has there been something that's damaged the relationship between employer and employee significantly. And the Vice President found, well, not really. He said that it was outside of work. The three victims, if we can call them that, outside of work, one or two weren't in the same area as Mr. Keenan, and so or would not have further contact with him beyond that party. One had mentioned that she wasn't offended by his relevant conduct, and so the Vice President said, well, if we look at it in totality, there's actually no ongoing impact in the workplace. So why should the joint venture have an interest in what he did outside of work? It wasn't during work. And so, ultimately, the Vice President found that the dismissal was harsh, unjust or unreasonable because Leighton Borough were not permitted to rely on what happened after the work event. And interestingly, the Vice President also made some reasonably critical comments about the fact that there was an open bar and free alcohol at the event. But ultimately, he decided that what happened afterwards was not at work, and so couldn't be relied upon. That's received some mixed responses, I think is the best way to explain it. The decision was appealed, but shortly following the appeal, the matter was settled. Now, whether that's because the parties perhaps thought that the decision was going to go the other way, whether it's a commercial matter, we'll never know. But at the end of the day, it was subject to an appeal, and we could have had a bit more clarity on this issue from the Commission. But unfortunately, because it's settled, the only decision we now have is the Vice President's decision.
Yeah, look, and I think the Vice President obviously feels very strongly about this particular point of out-of-hours conduct. He's had his own personal experience having been represented parties when he was a barrister in particular cases. One of those cases was another Telstra case, Telstra and Streeter, or Streeter and Telstra, depending on which the
appeal or
the first instance decision. And in that case, that was again another out-of-hours case, and we won't go into the details that we have with these other cases just now. But what was interesting about the Streeter case really is that whilst the out-of-hours conduct was ultimately not really the agitating factor, it was the honesty of the employee or the dishonesty of the employee during the investigation process. And so I might just take this opportunity to say that when you're dealing with these matters and you're investigating out-of-hours conduct, it's still important that from a procedural perspective that employees are given the usual sort of leeway or concessions that you might give to any employee. And I have to say that when you're dealing with human beings, a degree of self-preservation is going to kick in. And just because an employee's there's a degree of dishonesty, then you need to be careful about how you manage that. Now, ultimately, the Streeter case was upheld on appeal because she was found to have been dishonest during the investigation process, and the Commission upheld that. That's not always going to be the case. But when we look at this particular case, there were procedural errors beyond this issue of what occurred outside of work and what occurred during work. And there was issues about the exact nature or substance of the allegations that are being put to the employee in question, Mr. Keenan. And so it's really important to learn a lesson from this case that when you are disciplining an employee, that it's very clear what the allegations are. And the other thing was that the Vice President made a really significant point that was probably, some people would consider it to be a bit of an old school view, which is you have a duty of care to your employees, and when you're serving them alcohol, it is incumbent upon you, in accordance with your duty of care and your broader duty to your employees, to help them manage their alcohol intake. And if you're the one who's supplying the alcohol and they drink too much, then you will bear some responsibility for that. Now, societal view is that people need to take responsibility for their own conduct, and of course, from a criminal perspective, being drunk often isn't a very good excuse. But in the workplace, it's important when you have these events that the alcohol is properly managed, and that was an issue here as well.
Yeah, it's very difficult to divorce that from the overall findings, even though, as I said, there was legal reasons why he said you can't rely on these other things. You can't help but think that the fact they provide the alcohol had a bearing on it.
And look, there was another factor was that my understanding was a 10-year employee, he had 10 years service. That is always going to weigh significantly when you're talking about any dismissal case. An employee with 10 years service, they're going to be considering things like prospect of re-employment and whether or not it should have been something that was dealt with separately. And the Vice President went through, as you've just said, delineating between post-event relationships by pointing out that two of the employees didn't actually work in his department.
Mm. And so we're going to look at another one, another case in a moment, because we'll see a slightly different approach. And just before we move on from the Keenan and Borrell decision, my parting thought on that is I personally think that when we have a scenario where you have a Christmas party at a conference room in a hotel and people naturally spill out to the same location, we are in the same hotel but just the next bar down, the reality is you are still very much in the throes of that event. You are still very much part of a environment that was organised by work. And I actually think that there is very good merit in saying an employer should be able to discipline in that scenario for what happened at that public bar. And it's interesting because we then get to this next case, Rogers and Allianz Australia. We get a different approach taken, but I think it's a very similar type factual scenario. So in Rogers and Allianz, we have a scenario where a work team building event happened at a yacht club. The case talked about it being in the Olympic room. Now, I don't know what the Olympic room looks like, but I assume it's like any kind of conference room arranged in any type of function space. It's got your chairs, it's got your table, probably a nice whiteboard, and if they're sophisticated, maybe some video equipment. But what happens at the end of that social team building event is they then went to the members bar at the yacht club. And again, we're in the same type of venue. The social team or the team building exercises have really finished and some of the employees have kicked on for a drink. At this members bar, the employee, Mr. Rogers, started to get a bit aggressive about just being a bit disparaging about work. We see this quite a bit. People have a couple of drinks with their colleagues and all of a sudden all the complaints about work come out. And there was this odd interaction where two employees jokingly, according to Mr. Rogers, an employee bumped the other and one employee allegedly said something like, oh, you've just, and it was a male who said this, oh, you've just touched my vagina, is what he said. And everyone kind of laughed and it was apparently a joke that was said. Now, it's contested whether that was said or not, but that's what happened in the members bar. What happens after that is that they then decide to kick on even further, and Mr. Rogers and a female colleague, together with about 3 or 4 others, decide to go to another bar. Mr. Rogers and the female colleague enter into a cab together. The others go into another cab. And in that cab, they ended up in a heated disagreement about work things. And this is when Mr. Rogers said, and again, excuse the language, but he says to her, be quiet or I'll touch your vagina like everyone else has done tonight. Now, according to him, he said that because it was linked to this joke that had been said in the members bar. But that's in the context of being an individual male with a female in a taxi together, no one else around, that's quite a threatening and intimidating thing to say. And what Commissioner Rowe in this case found was that obviously that's entirely unacceptable, but he said that he had no difficulties in establishing a connection with the workplace. Firstly, he said the conduct is likely to cause serious damage to the relationship between employer and employee due to its offensive and threatening nature of the comment, and the absence of any regret or apology that had been expressed. Commissioner Rowe said it was necessary for the colleagues to work cooperatively in the workplace, and that the female employee was now worried about the incident for several weeks after it occurred. She reported it. She continued to feel uncomfortable in the workplace because of what had happened, and that it has had an impact on the workplace. He also said, the Commissioner, that there'd been no specified finishing time for the work function, and that the activity in the members bar, and this is where we start to get a distinction with the other case we've just talked about. He says he wasn't satisfied the activity in the members bar was unrelated. It was an unrelated private function. It was a continuation of what had occurred before, and the comments that Mr. Rogers ultimately made in the cab were in response to some discussions that had been had in the members bar. So he found a sufficient connection. And I suppose where that places us, and I'll throw this back to Joe, he can answer the tricky question, is, well, how do you reconcile the two cases? I mean,
I can reconcile them for you a little bit. And you can see that when you look at Commissioner Rowe's decision, he does go part of the way to distinguishing the circumstances, albeit on a very fine few points, between what occurred in Leighton, Borrolami and Keenan, or should I say Keenan and Leighton Borrolami, and the Rogers and Allianz decision before him. Now, in this particular decision, there's a couple of fine points. One is that he goes about very much like the Vice President in Keenan by analysing the discussion about the party continuing. And he makes a comment about them talking about kicking on and it being part of a group discussion with the other employees. So there's a bit of a flavour of there being a connection. And he makes the comment or the finding that he's not convinced that it was a separate function in any event. Secondly, what we do have is we do have two employees who work together, whereas you'll note in the Keenan decision, the Vice President made a comment or certainly made a point of the fact that two of the employees who were offended actually didn't work with this guy who was a roadside worker as far as I'm aware. These guys were people that worked in the office. There's very much difference between them, the difficulty of them working together post-event, and in this particular case, Rogers and Allianz, where you've got two employees who are going to see each other in the workplace. The other thing is that Commissioner Rowe also makes a comment about, and this is perhaps an issue that actually crosses both Keenan and the Rogers decision, is that Rowe goes so far as to point out the sensitivities around the sexual harassment element and the fact that you've got a male employee making some inappropriate sexual comments to a female employee. Now, you know, mark our words, the sexual harassment happens across genders and albeit most of the fighting incidents involve male on male, and most of the sexual harassment incidents do involve male on female, but it can occur otherwise. But in this particular case, Commissioner Rowe made a point of that being very much a difficulty in this case. So there are some fine points, but at the end of the day, they are, as you say, there's that thin grey line that arises, and it is, on one view, the factual circumstances are very similar. And one could say that with slightly differently tweaked factual circumstances, you might find that Mr. Rogers' decision could have gone the other way.
So that's kind of where we're at. The Rogers decision, so Keenan and Leighton Borrolami was 2015, the Rogers decision's 2017. So they're the two most recent and pivotal cases on these points, and we'll continue to watch with interest where it goes. I think that now leads us into, having looked at that, well, what is it that you should be doing? It is, no, we're not in November yet. We're late October. I've always been told and tend to subscribe to the view that the silly season officially commences from the Melbourne Cup, in the sense that once you've had the Melbourne Cup, the work events start at various workplaces. You see there's Christmas parties, there might be Melbourne Cup luncheons.
We know it does. From our own experience of the cases we get to hear about.
So it's about 2 weeks away that it officially kicks off, and from then on there can often be a lot of social events up to Christmas. And some of them you'll be organising, some of them you might not be. Well, what can we do?
Well, the first thing is that you'll have a code of conduct, and that code of conduct should set out very clearly what is expected of people's behaviour. It may even speak about work-related events and how people are expected to conduct themselves outside of the workplace. But regardless of whether you have a code of conduct or you do not, it's really important that prior to events, the expectations of behaviour are communicated to employees. That's the first thing. And, you know, we get the email every year from our parent company telling us that everyone's got to behave a particular way. Of course, we behave impeccably, always have.
Always.
And the other thing is, what we've learnt through these cases is having very clear start and finish times. That's another really important thing. And one of the other points that flows on to the issue about finish times is some directions about people about getting home, both from a duty of care perspective, but perhaps more broadly, just making sure your employees are getting home safely. Now, it doesn't mean you have to pay for them to get a cab home, but if you're having an event in a remote location, organise some transport. It might be a minibus, it might be cabs, it might be some other form of transport, but it can really help draw that line in the sand that this is when the work event finished, and if people decide to kick on, well, they may do so in their own time, and it really does draw that more definite line between what occurred at work and after work. Now, the other thing, of course, is we've already spoken about the issue in Keenan, and that is you still need to give people directions about consumption of alcohol. probably shouldn't need to be said about drugs, but again, if you've got a drug or alcohol policy in the workplace, you should tell employees that when they come to work events, they're expected to conduct themselves as if they were at work in a polite, appropriate manner, and that includes refraining from taking drugs or alcohol, except if it's an alcohol-related event, of course, drinking alcohol in moderation.
Yeah, and you need, I think in terms of the directions and things like that, just the start and finishing times, one thing I was going to say is we saw in the Rogers case there was no official finishing time, and that brought it very much within the view of the Commission. We saw in the Keenan case they did have a set finishing time, and that changed the complexion. The reason that's important, it's not about also whether you can or can't discipline, but it's going to have a significant impact on your exposure to liability from discrimination and harassment laws. So if someone brings a discrimination or harassment claim against you as an employer, if you can establish that what happened was outside of work, as an employer you may not be very vicariously liable. But if you didn't have that set finish time, all of a sudden you have a much greater chance of being vicariously liable for what happened later on. And I think part of that as well with the finish time is actually to move people on. So you cannot stop someone kicking on. People are able to kick on, have after parties, all those kinds of things. They don't necessarily have to have them in the immediate vicinity of where you had your Christmas party. So you can just have security there that ensures that if your event ends at 10 or 11 o'clock, they move everyone on. If they go to the other side of town and kick on, so be it. That's probably clearly going to be outside of work.
And just a pre-work event planning issue that we haven't got in our list but is important, and it's one of the questions that's asked here, is inviting partners to events. Yeah. And my advice about that would be to approach that prospect with caution. And the reason that I say that is because we have had our fair share of cases that have arisen in connection with clients and members of the business chamber as to people who've brought their partners along and their partners haven't really mixed well with other colleagues.
You're being very diplomatic. They're the ones who start the fights.
Yes.
The partners.
And whether it's the jealous boyfriend who's come along and doesn't like the dynamic between their girlfriend who works at the workplace and someone else in the workplace, or it happens to be a professional dispute, it's really important that you think very carefully about what the party involves and whether or not it's appropriate to bring along partners. I would suggest you wouldn't in most circumstances. It's a work-related function. Yes, you spend most of your life at work. You have your work colleagues. You don't normally have that additional element of the personalities of people's partners being injected into the workplace, and you will find a very different dynamic in most circumstances.
Yep. So then, I suppose, in terms of tips at the event, I've already mentioned one of them, which was about moving people on. Responsible service of alcohol. It goes without saying now, isn't it?
It certainly does, and in fact, it's one of the questions we've just got here is, how do we monitor that? Look, not all businesses can afford to actually hire someone who has an RSA certificate to come along and serve alcohol, but obviously that's one of the ways that you can monitor it, because the person who has their RSA certificate has been trained and they're now qualified to serve alcohol in a responsible service manner. Now, obviously it wouldn't hurt to have a conversation with those bar staff in advance as well, or through their organisation, to make sure they're briefed, inducted if you will. But it is important that if you are going to serve alcohol that you give people clear directions, and if you want to monitor it, then look, senior staff, it's really incumbent upon them to keep an eye on everyone. I'm not talking about snooping, I'm not talking about eavesdropping or domineering, but I am suggesting that senior people in the workplace will be the ones that will have to deal with the mess. They could ultimately be found to be partly responsible in certain circumstances for the conduct or the fallout from negative conduct. And so it's really important, not just in relation to alcohol, but the broader mood of the workplace, that senior staff take responsibility and understand that they need to stay ahead of the curve and stay ahead of issues arising.
And I suppose in terms of the only other thing, we were going to talk about what happens after the event. Well, I think Joe's already touched on transport home. What's your view, Joe, on people coming back to work after the event, or limiting the ability to do that?
Look, I think my general rule would be they shouldn't come back to work. They shouldn't come back to the office. That happens. We know that there are some cases involving people who've late at night decided that it's a good idea to go back to the office for various reasons. for various reasons, and that usually doesn't end well for those individuals when they get caught. So my view is, look, when you have a work-related event involving alcohol, that should be the end of work, really, once that ends. There is another question just asked here about drugs. Again, what's the responsibility of senior employees if we become aware of employees using illegal drugs in the bathroom? Well, if it's at a work event and it's at work, then and you've got a drug and alcohol policy, then you might manage that person in accordance with the drug and alcohol policy. Depends on what sort of drugs you're talking about, of course. They might be prescription drugs, and they might be taking prescription drugs they're not entitled to take, or they might be illicit drugs, cocaine, marijuana, speed, whatever you want to call it. They should really be managed in accordance with your policies if it is the work function. Of course, if you know that an employee is taking drugs, then that might be a broader issue and one that you need to deal with in the workplace post-event as well.
Yep.
That's a different issue, of course.
All right, so that's kind of the tips that we had for actually dealing with your Christmas event. I suppose the way we're going to close off before addressing any final questions any of you may have out there, and please feel free to send in your questions, is, well, what do we do and how do we approach an issue if something has happened at the Christmas party event, it happens late at night, it's on a Friday night, you get in Monday morning, and all of a sudden the call comes in. I mean, our advice line, which services a lot of services 20,000 odd calls for New South Wales Business Chamber members in the year. There's no doubt that Monday mornings in December are very busy. There's no doubt that the period between Christmas and New Year even gets a number of calls about things that happen at Christmas parties. So Monday morning's when the call comes in usually, and something's happened. How is it that we approach this? And what we thought we'd do is give you a very quick refresher on what the usual process for discipline reaction should be. The first thing you have to do is you need to commence an investigation. And to do that, we're talking about the usual procedural steps you would do in any type of investigation format. You need to be finding out as much as you can about the event. There might be CCTV footage, there might be witnesses, you want to speak to them, gather the relevant information. You then really need to be in a position that you're going to put what you believe has happened to the employee to get their response. So the next step in terms of a fair and a proper process to find out what happened is to get their response. You will likely be providing them with a support person at that point in time if you're going to do that, because if it is a case that might lead to dismissal, it's very important that they have the opportunity to have a support person present. But at that point, you want to get their response. You're probably then going to be revisiting at that stage, well, is there any further information I need? If so, do I need to go to certain other people to get that information? And then finally, you're going to be making your finding as to what actually happened. And they are effectively your findings. And then following on from that, that's when you're going to have to decide about what sanction you might implement. That's a basic investigation process. There are a whole range of more detailed questions about how you're going to go about finding out who do I speak to, how am I going to record the evidence that I take, am I going to be taking notes, am I going to be taking witness statements, am I going to be recording the interviews. But at the end of the day, what you need to ensure is I've interviewed the relevant people, I've looked at any geographical location, footage, recordings, I've put all the allegations to the employee, I've gotten their response, and then I make findings as to what happened. Once you've made those findings as to what happened, at that point, you're in a position to what we colloquially call show cause an employee, and that is to say, this is the disciplinary sanction I'm thinking of implementing. What do you have to say in response to that? You genuinely consider their response, and at that point you can make your decision. That's the basic process.
Yeah, look, it definitely is, but I think one of the key things we need to say through that process is don't be too rigid in your process, in the sense that you'll see it as being work-related conduct, you'll be investigating it in the first instance in that respect, you'll go through the analysis as Lewis has just talked about going through, and you'll come to a view about location, the conduct, and whether or not it has sufficient connection with the workplace. And where people usually get lost is when they just they don't look at the broader picture. And I think when you look at the Rogers case, you can see that Rowe looked beyond that. He looked to the fact that these people are going to have to work together later on. Those are factors that can be taken into account. But it's very important you give them careful consideration and you examine those elements. And it might slow the process down a little bit. But it means that if you've got an employee like Mr. Rogers, for example, who is engaging with this female, Ms. Farrelly, who he offended, when you go through that process, you do need to isolate the elements that are non-work related and form a view very clearly whether or not that is an operative reason as to why you were going to terminate this person's employment or take other disciplinary action against them. And because there's a bunch of cases where there are employees who've engaged in conduct that are completely outside of the workplace. They're not party events. I mean, if we look at Cole Dashian and Lion Nathan, that was a fellow who was drink driving outside of work hours. He ultimately, because he works for an alcohol company, there were two elements there. There was an element where he was driving down the back streets to avoid the breathalyzers, and he was working for an alcohol company. So that demonstrates that you can still take disciplinary action for employees for out-of-hours conduct. You know, there's other cases like the Fitzgerald hair design case. Fitzgerald, and in that particular case, you know, the commissioner held that you could take action for the out-of-hours conduct, but you needed to be careful that you weren't overreacting. In that particular case, they dismissed the young lady, and they shouldn't have done that because it only really warranted a warning. So it's really important when we look at these cases that we've just been talking about. I think what happened is the employers got focused on process and focused on the conduct being repugnant from a societal perspective, the conduct being so serious during work hours that it warranted dismissal, and that's what tainted the Keenan case. It was okay in the Rogers case, but really when I think very carefully about the Keenan case, and you have to, because you know, I have no doubt that the Vice President will follow a very similar process if another case ends up before him, and my tip to employers would be when you're going through that process, you might need to change tact. And if you change tact and it becomes more about the employee not being able to work with people outside of work, like post-event, you need to explore things like mediation and reconciliation between those employees. It may not occur, and in fact, most employees, like Mr. Rogers, demonstrated a lack of remorse for his behaviour. That was taken into account. But without being given the opportunity, some of these members of the Fair Work Commission will consider that you've judged it too early and you've categorised it incorrectly, the conduct. I think that in the Keenan case, if they'd gone a little bit further and spent a little bit more time looking about post-work event, it might have been a different result. I mean, we'll never know. We'll never know.
Yeah, and I think, I mean, that feeds into something on the previous slide, which is when we talk about the ultimate sanction, which is dismissal, you really need to ask yourself, well, do I have a valid reason to terminate? So it needs to be sound, it needs to be defensible, it needs to be based on fact. But more than that, in an unfair dismissal proceeding, they're going to look at whether there are mitigating circumstances. And so they're going to be looking at things like, well, how long is their length of service? Were there other reasons why they may have behaved the way they did? What's been the impact of the dismissal on them? What's the likelihood of getting new work? How old are they? What's their job mobility prospects? And you need to take all of that into consideration before you make that final step and that final decision. And because that's what the Commission's going to do. So if that's what they're going to be doing, you need to be making sure you're taking yourself through the same thinking process when you're making that final decision about to terminate or not. So we've kind of talked about the process already. We've got a slide up there that just goes through the steps that we've really already talked to you about. I think the only other thing that we haven't kind of drilled into, which we might just very quickly touch on, is in relation to the support person. We get a lot of tension, a lot of debate about the role of the support person. My 2 cents on this is I think most HR managers these days have a pretty good understanding that the support person is there to provide support, emotional support to the employee. They should not be there as a representative. They are there to effectively, be there, and if, for instance, someone needs a break, they might go and have a break with them, but they're not there to actually provide responses on behalf of the employee. The only issue I have is we see a lot of cases come up where part of the unfair dismissal case is that the employer has absolutely hounded the support person when they walk into the room about, you sit there, you can't say anything, you kind of shut up, sit there, and there's this kind of initially aggressive approach to the support person that's unnecessary. I mean, my general approach, and Joe, please tell me if you think a different or there's other ways of doing it, but my general approach is you've got the support person there, they've been offered access, great. You would bring them in. If you want to explain a bit about the process, you might do that, and you might say, look, ultimately we're going to be asking questions of the employee and we need a response from them. Obviously you're here just to provide support. So, but you probably just leave it at that. And at the end of the day, if the support person starts playing up, that's when you might need to be a bit more firm about, look, your role really is here not to actually interject or to interfere with the interview process, it's to provide support. And you might have that discussion with them if they start to misbehave. But I do have a bit of an adverse reaction to these managers that seem to be going out there and berating the support person before it's even the process is kicked off. It seems to be a bad way to start a fact-finding process.
Look, it is, and it's a distraction. And in fact, some representatives will use it as a distraction, and they'll use it to their advantage, particularly if their client or member or the person they're supporting has actually engaged in some pretty bad behaviour. There's three things I'd just like to say about that. The first one is that one of the fetters on this issue about support people not being representatives is if there's something in your enterprise agreement, just be very careful, because some enterprise agreements, certainly not ones we'd be responsible for drafting, but some enterprise agreements include in them an entitlement or a right to be represented at all stages through their employment by usually their union. But it might be a broader representation provision, in which case they might bring a lawyer or someone else to come along and represent them. So just be very careful if you've got an enterprise agreement. I won't say anything more about that. Just you should always comply with the enterprise agreement. The second thing is where you are involved with an employee who has a union representative, where that union representative insists that they're going to be a representative and not just a support person, don't fight them about it. Find a way to work through the questioning process. Allow the union representative to have something to say. But there are points at which you will need a direct answer from the employee concerned, because one of the things we do find is, you know, later on in a process, an employee claims that their representative said something that wasn't actually in their words or wasn't what they meant. And they'll get some forgiveness for that. Representative errors are very popular, and it gets them good results in unfair dismissal cases and out-of-time applications and the like. The last situation I wanted to talk about was lawyers, those painful creatures called lawyers. Now, one of the issues with lawyers is that employees think it's a good idea to bring along their lawyers. Perhaps mostly less experienced lawyers will go along to a disciplinary meeting. Sometimes we get asked to go along. We prefer not to, because one of the things we're taught when we become lawyers is don't become a witness in your client's case. And what I usually do is I usually say to the client, look, putting to one side any small business rules about lawyers not being involved in as a support person, with larger businesses, when they approach us with this challenge, what I say to them is this: go back to the employee and say, look, we're happy for your lawyer to be involved, but there's a few rules. Obviously, they're here as a support person, so we need to hear directly from you about certain things. We're happy to hear what they have to say about it if they want to make some submissions. We don't really need their views or their opinions, but if they want to put them on the record, that's fine. Secondly, I would say to them, look, our lawyers tell us that they don't usually involve themselves because they become a witness in their client's case. And often the employee goes off and tells the lawyer, oh, this is what they've told me, you can come along, but you're going to be a witness in this case. Very quickly, in about 9 out of 10 cases at least, the lawyer's no longer coming along to the meeting because they realise they're going to be a witness. And they may not be able to represent the employee if there's going to be a dispute about what happened in that particular meeting. So that's what I'll say about support persons. Don't make it the case, is what the point Lewis is making. Do not make support people the case. It needs to be about the conduct.
Yeah. So that's broadly what we wanted to cover today. I think there are some questions. Question time now.
There are. So we've got a few questions here. There are a couple of questions about kicking on and how do we draw a line in the sand about that. We've talked about that. But there's also a concern here about journey claims. Now, in New South Wales, work-to-home journey claims are no longer an issue under workers' comp, so you don't need to worry about that. But I generally tend to take the view that when we're talking about broader legal risk issues, then it's really important that you do take care of the issues at either end. And I've already spoken about my recommendations around thinking about what's going to happen at the end of the event. But if people are going to kick on, they kick on at their own discretion, and that should be made very carefully. If you go on to another event, whilst this will not be work-related, we do remind you that you should still, conduct yourself appropriately around your colleagues. It's a difficult issue to manage when there's something negative happens or poor conduct that rises as a result of it. So that's what I'll say about that. It can help if you can organise transport or make it available at least, and tell people that taxis are going to be made available. The more remote the party, the more important it is to arrange that travel. Yeah. Some other questions here. If you're taking staff away for several days and events at night, including alcohol, can you delineate work time from personal leisure, or will the whole time be regarded as work-related? This is really important. If you're going to try and delineate between personal time and work time, then you are going to have to provide some rules. You will find, however, that when we talk about workers' comp and broader legal risks, that when you send people away on work assignments, they're often at work the majority of the time. And then, of course, there was a significant case involving an employee working for one of the Commonwealth government agencies where there was an event in a hotel room. I'll talk about that event. But nonetheless, she suffered a head injury and she sued the government as a result. And there was a range of decisions that went either way. She was at work or she wasn't at work at the time, and it wasn't a work incident rising out of her in the course of her employment. Regardless of what the outcome of those cases are, it is really important if you're going to try and draw a line between when a person is at work and not at work, you're going to have to be very clear about it. But my view would be that while they're away on a work function in a remote location, the majority of that time is going to be they're at work.
Yeah, most probably.
Yeah. There's been a few questions about the when you're away. Where do you stand if you host the event in your workplace and you have an incident?
You host the event in your workplace and you have an incident. Well, I suppose you've got a couple of issues there. If it's in your workplace, it's likely going to be at work. So then the question we're talking about, well, what kind of incident? If we're talking about a disciplinary issue, I think you're very much looking like, as an employer, you have a right to discipline for that issue. If it's a safety incident that we're talking about, quite quickly you've got all your usual OHS or WHS safety obligations that kick in as well. Is it actually a notifiable event? Is it something where you need to let the regulator know pretty quickly? Do you need to make sure you take steps to make the workplace safe? I would say yes to all of those questions. But if it's at the workplace, it's something you've organised for staff there, I'd say it's at work.
I agree, and there's another question here which I think is a really important one, a good one for you and me too, Lewis, in our particular circumstances, being directors of the firm. If senior employees choose to kick on following a Christmas party, does this blur the lines when the Christmas party ends? What if all employees choose to kick on? Now, I've got a particular view about this. And my view is that, yes, senior employees do have to be very careful when they kick on. It doesn't automatically make it a work-related event, but they have to be careful from a dynamic perspective, but also more broadly from is this a subsequent work event? Are they using the work credit card? Are they making the decisions about where they're heading? Are they still acting like the boss? And I think all of those things will come into it. So, I mean, it's difficult to say you can't go because there's obviously broader cultural and, relationship issues with if the boss never goes out for a drink with the staff, then, there's a thing about breaking bread with your staff and building relationships. But at the same time, I think there's a balance, and senior staff need to be very careful about what they're doing when they are going out.
And I think the moment the work credit card's coming out, I think that's going to be a big factor that the Commission's going to look at, and a court looking at a discrimination claim, those type of things will look at and say, well, looks like it's got still a fair connection to the workplace. I think that's pretty much all we've got time for today. We have available to the listeners today and our viewers, I should say, because you're not just listeners. You're one of our first webcasts, so it's all a bit of a new experience to us. But we have available a letter template that we're offering to all our viewers to provide to staff in advance of a Christmas party event so that you can cover off on the types of obligations that we've talked about today. So that is available, And obviously, if you have any questions in relation to any of what we've discussed today, you have all our contact details up there. But Joe and I would be more than happy to take your call. As you can tell, we could talk all day about this matter, so we'll happily talk to you about it too.
Thanks, Lewis.
All right. Thank you, Joe.